Good evening, everyone, and a warm welcome to our session, Digital Health, Privacy and Security at the Core. In today's rapidly advancing digital healthcare landscape, safeguarding citizen data is paramount. In today's discussion, we will delve into critical aspects of safeguarding privacy and ensuring security in the domain of digital health. Without further delay, it is my honor to welcome our distinguished panel, chaired by Mr. J. Satyanarayana, a veteran in the Indian Administrative Service with over 37 years of experience. He served as the chairman of National Digital Health Blueprint. Our first panelist today is Dr. P. Ashok Babu. He's from Indian Administrative Services of 2003 batch of Assam Meghalaya cadre. He is presently serving as the Joint Secretary, Department of Health and Family Welfare. Next, we have Mr. Deepak Goel. He is the Head of Division of Data Governance, E-Division, and has been actively involved in framing of the Digital Personal Data Protection Act. Next, we welcome Mr. Rahul Matthan, a partner at Tri-Legal, Bengaluru, with expertise in technology sector, including data protection, digital finance, and more. Our next panelist is Mr. Anirudh Rastogi, the founder of Ikigai Law, an award-winning law firm which specializes in representing innovation-led business. Finally, we have our moderator, Mr. Kiran Anandampillai, CEO of Shri Eye Care, who also contributes as a technology advisor at the National Health Authority. I'd like to now hand over the stage to Mr. Kiran Anandampillai to open today's session.
Thank you, and a warm welcome to everyone for this evening session. We have an amazing set of panelists in front of us, including J. Satyanarayana sir, who's been behind the concepts and all the constructs behind ABDM. I think with health data, all of us, everyone in the room, including me, are always wondering about with ABDM, how is it that the new digital personal data protection bill is actually going to apply and impact health data. So what we're going to try to do in today's session is to try to learn a little more about it from the panelists. And I would like to start by requesting our chair, J. Satyanarayana sir, to share his words of wisdom, also his insights into this topic and set the context for getting the ball rolling. Sir.
Thank you, Kiran, fellow panelists, and all the distinguished invitees. Really, it's a great pleasure to be here for me. Also, personally, because on this day, 5 years ago, when the scheme was launched, PNJ scheme was launched in Ranchi by the Honorable Prime Minister, I happened to be there. And we had to do this in 100 days. We launched this program from word go to the launch on 25th September. Happened in less than 100 days. So it's a great pleasure that today we're celebrating 5 years. And also 2 years of Ayushman Bharat Digital Mission. We are also, as mentioned by the moderator Kiran, that I had the privilege of being the chair of the National Digital Health Blueprint Committee at that time. So I think there was, in the previous session, there was also a little bit discussion on the privacy aspects, especially from the perspective of Aadhaar and ABBA, and Aadhaar versus ABBA, Aadhaar for ABBA, etc. So it was an interesting point to pick up from, and what I intend to do is, we have eminent legal and administrative experts here on both my sides, and my job would be to raise a few issues, make a few suggestions and observations initially. So let me, can you please have the presentation up and there? I have a few slides to sort of cut and razor. Can you please launch the presentation, please? Yeah, thank you. So privacy and security, both like two sides of a coin, they are being treated in this session. So initially there is the first point, of course, is privacy is a fundamental right. When we were actually designing this 5 years ago, or even earlier, 2017, 16, etc., we didn't have this verdict of the Honorable Supreme Court. So things were in a kind of a debating stage at that point of time, but there is a complete clarity post the Honorable Supreme Court's judgment. And what we are dealing with is a kind of a sensitive personal data in this field, and that's why the data protection here becomes doubly important in the health sector. Now, in terms of ABDM, Ayushman Bharat Digital Mission, a number of features of the mission, the way it is designed, cater to the needs of privacy. First and foremost is the federated architecture, which means that no data is held centrally except which is really core of the core. And the data, health data of individuals resides with wherever it is created. And then also in the architecture, if you observe closely, there is two innovative concepts which have been introduced, like privacy operations center, just like security operations center were well established for decades. Since privacy is equally important and going to be more and more important going forward, how do we take a leaf from the SOC, scores of hundreds of SOCs that are available in India and abroad? How do you take a cue from that and build something for privacy there? Second one is about anonymization. So these are built into the architecture. Secondly, privacy and security by design is another principle on which the entire architecture is. That means every building block is prefixed with privacy features rather than trying to retrofit privacy into the program. Retrofitting is always messy and difficult, so privacy and security by design have been ingrained into the architecture. The third is, when we were launching ABDM, there was a vacuum. We didn't have DPDP bill, and we had to go forward somehow, and then the data management policy as a sort of a go forward approach was adopted in 2020. It was notified, and it also advocates the consent manager, which is now one of the key pillars of the DPDP Act. Finally, the voluntary nature of participation is one more thing. If you want, it's not, there is no compulsion that you take a ABHA number or HPR, HFR. So that's one more feature which advocates or supports the privacy perspective. So these are the considerations we had at that time. And then let me spend having, because the theme is privacy and security, I just thought that we need to spend a minute on this. What do we exactly mean by privacy? What are the requirements? What are the principles which are fundamental to privacy? These are also, buttressed and reinforced, emphasized in the Puttaswamy judgment as well. I need not go into details except to say that these 9 principles, which are available boldly on the screen, they have been incorporated in the data privacy policy published by ABDM and notified by the NHA. So these are also, when you see, when these provisions or principles against the DPDP Act, all of them are in consonance with DP Act, and there is nothing which is sidestepping. So this is one point I would like to bring to notice of the House. Second one is, similarly, the 9 principles. Security by design means you plan for a breach, you plan against a breach of security, and then design the systems so that every screen, every line of code reeks of security. So these are the principles. I don't want to go into details except to raise the importance of the security by design, right, at this point of time. Finally, when you, the session is about privacy and security closely on the heels of the act having been, legislated recently by the Parliament. So the questions naturally come, what does the DPDP Act bring, over and above what is already being done? What is new there? What is not covered by the existing position? So just a comparative picture here. If you see all the actors who are there in the healthcare sector, which are relevant from the perspective of ABDM, either it is a patient, it is a health facility, it is a software, hardware providers, the apps and other health lockers which have been championed by ABDM, and the healthcare professionals to whom again a distinct identity has been given. So there is a distinct place for them. They map very nicely to DPDP Act, except the last one is debatable whether a healthcare professional. I think the legal pundits here should probably throw more light on that. Do they fall under the category, the doctors, specialists, etc., do they come under the definition of data fiduciary at all, and what are their obligations in this regard? The next one is about the same thing. When you compare the policy of 2020, which is currently being followed, the ABDM has come up with another draft, improved version, enhanced version of that last year, but it still remains a draft. Hopefully, once the now that the act is passed, so this draft probably will become policy pretty soon. That's only my expectation. Then if you compare this again, what is already being practiced for the last 3 years versus what has the act, the most recent act, to do with this. So again there is a considerable coincidence and convergence of what is already there in the policy versus what is there in the DPDP Act. So only a couple of things here, that the consent manager, which is referred to in the current policy being implemented by ABDM, is a technical artifact, is a technical platform or a technical construct, and is an electronic system versus in the act, consent manager assumes flesh and blood, say an entity which is also responsible for the platform, has also the obligations, etc. So that's one distinct difference that I noticed. Secondly, things like significant data fiduciary was not envisaged at the time the policy was drafted and is being implemented, and also provisions like data protection board and appellate tribunal obviously are not part of the policy. So this is the kind of slight difference between the current policy, and there is no great divergence, I will say, but some kind of supplementation will be needed going forward, in terms of the data management policy for Ayushman Bharat. Lastly, these questions I think are more for Kiran to take them forward across the other distinguished panelists here who have rich knowledge on the subject of privacy and security. So with these few words, again, I compliment Ayushman Bharat Digital Mission and NHA for this crossing these very important milestones, 5 years and 2 years. A lot of other numbers which go into crores, I don't want to repeat that. Congratulations once again. All the best going forward. So with this, I will pass it on to Kiran to conduct the rest of the session.
Thank you so much, sir. I think it was wonderful to see how the thought process that you have led in the creation of ABDM is so aligned to the DPDP Act. I think for all of us in healthcare here, the key thing is it's very clear that if you are a health facility or if you're a public health or in public health, clearly there is going to be quite a bit of implications as the DPDP Act starts to roll out, and all of us will need to comply. Now the questions therefore become, what is it really that each of us will have to do to comply with it? And so let's try to see if we can get some insights from our panelists. I'd like to start with Dr. Ashok Babu sir. Sir, you're currently handling some of the largest public health programs with a humongous amount of data in the country. So, could you tell us your opinion on what do you see as the implications of the DPDP Act, especially when it comes to public health programs?
Thank you, respected Chair. Thank you for the opportunity. The question to me is whether we are managing this much of data, what are the implications of DP for us? If you look at the things, initially maybe 1 decade or 2 decades ago, whenever there is a health problem, say maternal mortality, how much it is there if you have to measure. We used to have every 5 years or every 10 years one data. And we used to see that number and know, yes, this is the problem. And we work for 3 years and see one more number. Okay, the problem is reduced because we are doing some public health actions. From that blindness, the ministry moved to one particular system where everybody is monitored. With that idea, from the ministry, the thought process is to give personal care for the personal problem of everybody. With that, some aggressiveness has started. It is not just identifying one individual mother or a pregnant woman. Can I plot her through the life cycle approach right from when she is adolescent girl, she is pregnant, she delivered, what is happening thereafter? You can call it personal care, you can call it more invasion into the privacy. Then through that, one advantage also has happened. If you see when the world is reducing at some 40%, India is reducing maternal mortality by 70% in the last 1 decade or so. What this personal care has offered, it is more into the personal aspects, more into the care also. Not just the government stopped at that point. It started making virtual calendar for the advanced actions which I need to do for that particular woman. Can we call it much more personal invasion? Say, last menstrual period I get to know, plus 9 months, one software, I get to know when there will be expected date of delivery. Minus 2 months, I know when the tetanus toxoid vaccine has to be given to her. So, we started going more and more into the personal aspects and added with more technology. We started giving SMS well in advance, be ready, you are going to have this one, be ready like that. When we moved this much aggressively into the personal sphere of a woman, naturally this DPDP makes us to think twice in certain aspects, what we call the implications for us. Henceforth, the government, I mean to say we, should be very much careful about what is sensitive information, what is non-sensitive information. This is the first lesson for us. Say, we give free of cost comprehensive abortion care. Approximately 50 lakh women take the services. Should we take the data of abortions also into our system or just vaccination? So when I say sensitive and non-sensitive data, we should be very careful about it. Then second aspect is, of late we started, while taking the data, the consent. Now, during one of our initiatives in TB program, one of the ways to drive the stigma away is, we requested individuals, political parties, industries, can you adopt a TB patient? Approximately 1 lakh people said, yes, we will adopt. Can I share the mobile numbers, household address and everything of a TB patient without consent? It's a good way. He adopts, he gives nutrition, he takes care of him. So we learned approximately 25% of the people did not give consent, though we wanted to give benefit. So the second lesson for us is to take consent even if your intentions are good, because DPDP has come into picture. Then the third aspect is we should limit ourselves into certain aspects. Say somebody is having anemia. Should I stop at that point, or somebody is given iron folic acid tablets or not? Somebody is consuming it or not? Somebody is dropping there or not? Shall I send Asha to his home or not? These rest of the 4 data, points. Do I require or I don't? Or should I leave to somebody else? So the third aspect is we should limit ourselves in not reaching into every and each aspect of the individual person. And the last point, we should be double or triple careful about the technologies which we are using, especially to keep it safe and secure so that the trust of the consumer, the beneficiary, is very important when we attempt this limited nature or personal care, etc. We have to win the trust also. To win the trust, our technology should be safer enough, and we are thinking about it very carefully these days. Thank you.
Excellent. Excellent points, sir, and I'm absolutely happy to hear the thought process that you have as this comes out. Clearly going to be very, very important as to how it plays out in the future. I'm just going to move to, we have a couple of lawyers on our team, and I think it will be good for all of us to understand the panel today. So we'll start with Anirudh. Anirudh, one of the things that is very interesting is that the DPDP bill actually brings in a lot of rights to the data principle. So as Jay Satyanarayana sir was sharing, any patient becomes a data principle. So tell us a bit about what rights can I as a patient expect after from healthcare providers after the DPDP bill is in play.
Thanks for that, Kiran. So one thing that we need to understand is that the individual who's parting with their data is pretty much at the center of the focal point of the DPDP Act. And therefore the rights, I mean, the Act does a good job in enumerating and identifying several rights of the individual, the data principle in this case. Now, apart from the fact that, of course, I think I won't go into the general principles of notice and consent, which I think we've already discussed at some length, the rights that a data principal will have, typically, namely one, that they can at any point in time request for a summary of whatever data is held by a data fiduciary, right? They can request for any transfer of data to be, so any third party who has been given that data the principal can then request for a list of all these entities that the data has been transferred to. They can ask for correction of their data at any point in time, updation of their data, erasure of their data, and a right for grievance redressal as well. Now, what is important, therefore, to understand here is that these rights, to enable these rights, I think data fiduciaries will necessarily have to have some tooling at the back end where they are able to properly inventorize what data they have, understand how that data is flowing through their system to third parties and under what kind of transfer conditions, their ability to correct that data upon a request wherever it is stored, and it could be stored at multiple layers and multiple places in the etc. So your ability to correct it, update it, erase it, right? And so all of that, the tooling that is necessary to make this happen, I think, will become important. And that's just one message that I want to leave this room with, that, whether you are a data fiduciary, in this case, a doctor, hospital, clinic, you are a software provider, you're an insurance provider, you will have to have some kind of back-end tooling that is integrated, seamlessly working across wherever the data is flowing.
Yeah, thanks. I'm not sure if you provided comfort to the room or you made them scared. For one thing I know, having worked in this space, is that doctors don't tend to be the most IT savvy. India has 200,000 healthcare providers. The amount of IT investment that the industry makes is actually pretty low. So, Rahul, I'd like to move to you. Almost anything that we do digitally today, we keep talking about electronic health records. Everything is actually information that's produced on some piece of software. That software is made by some entity. So as the DPDP Act comes into play, we saw this chart from Jay Satyanarayana sir, which put the health facility as the data fiduciary. I have seen a whole bunch of penalties primarily applied to the data fiduciary. Now, what is the role of this software provider, the HMIS provider or the LMIS provider? How much should a doctor care
or a facility care when it picks the software? What should they really care about? What should they make sure that is in the right place as they kind of make these decisions?
So if you thought that that was a question that was going to provoke comfort, then I must disabuse you of that notion right away. First of all, I'm very glad to be here. I think it was here at Vigyan Bhavan that you launched the original ABDM blueprint. And I remember looking at that document as it was launched, saying this is a completely forward-thinking approach to regulating health. And you can see that 5-6 years afterwards, it's an advanced forward-thinking law matches it almost like section to section, if you look through all the sections that are similar. So, look, I think we have moved into a new paradigm. The new paradigm is that data is going to be protected. So to answer your question, Kiran, I think that the responsibilities on the data fiduciaries have now reached a very high level. The implication in your question is that because the software provider is providing us the software, that we are less responsible. I don't think that is true. At the end of the day, the data fiduciary is the person who controls the purpose and means of processing. Whoever that is the one that is responsible as a data fiduciary. You may identify software vendors that could help you do this better, more efficiently, all of those various things. But if anything goes wrong, it is you who is responsible as the data fiduciary. And once again, as a lawyer, the real answer, Kiran, to your question is it depends, because for all lawyers, that is really the way we answer our questions. And it does depend, because there are situations where the nature of the software provider could make the software provider also a fiduciary for some aspects. But if the software provider is merely providing you technology, and you are using the technology to decide the purpose and means of processing, then you cannot say that you gave me software, you are responsible. But if the software provider is providing you, say, like a complete SaaS offering, where they're also saying, look, I will move data from another place to here, I will give you like complex data that you can use. At that point in time, maybe they elevate to the level of what we call a joint fiduciary. Now, there's no such concept. Deepak is he knows the law more than me, quite frankly. But the concept of joint fiduciary is not alien to this law. And so you could have a situation where the software provider as well as the hospital, health facility are joint fiduciaries. But I don't see any situation where because you have used software that you will stop being responsible for the data that you have. Can I be any more depressing, Kiran?
No, well, I think what it tells me, and I think I can see business coming to lawyers, so that doctors make sure that the contract between them and the software providers is airtight, and that they don't get cut, because if there is a software issue and the data fiduciary law comes into place. That's really where I can see where their answer is going. But I think that's it's really good to understand, and I think all of us who are going to likely to be data fiduciaries should take note that we will have responsibility in the choices we make about how we process, use, and manage data. I think moving to Deepak sir, you have been part of the drafting of the act, as well as now looking, we're all anticipating or waiting for the rules to come out. So while we are in the waiting zone, I would love to hear how is it currently being visualized in terms of the implementation timeframes. Do we see different types of data fiduciaries potentially getting different timelines? Do we see everyone getting it? So what is the implications for hospitals or in the healthcare sector as you see it today?
Thank you, Satya sir. Thank you, Kiranji. First, a caveat first. I am not a lawyer. I am a technocrat. worked for IT profession, worked as an IT professional. Just to soothe a bit what Rahul has said, all data fiduciaries can have a legal contract with the data processor. So that particular data processor would be the software provider on which the data health professionals as a data fiduciary would work. So now another job for friends Rahul and Anirudh to make a watertight type of an contract, which could save data fiduciary, means who can, if healthcare professionals can influence the lawyers, or let's see the software providers can influence. So now coming to the Kiran's question, hope it suits a bit. After having enacted the law, the next process is just to go through the motions of the rules. So that would basically complete the complete ecosystem of the legal jurisprudence around this Personal Data Protection Act. I would just simply like to emphasize here one particular point, that this act is specifically for the protection of digital personal data. And then my finance data, my health data, my transport related data, my travel data, they are all basically aligned to that. So sectoral laws will always be in place along with this Digital Personal Data Protection Act. And one more thing, what Satya sir was and Ashok sir was also saying, that sensitive personal data. Actually, in this particular act, we have not differentiated between the personal data. It's all type of data would be covered in a uniform single block type of a fashion. Means, and in the earlier draft of this digital personal data protection, means what was in 2019, we had 3 types of data. So that's why we are coming so often with that. So we don't have any sensitive personal data. So whatever data the health professionals are processing, so it's all covered in a single way. One particular question, what Satya sir said was the consent manager. So I would just like to add that consent manager would work as an entity. Right now, we are looking them as an conglomerations of IT systems, but I think as we grow into the more and more usages and we see the more and more consent managers, so we are looking at it as in that they would be coming as as an entity, they would be controlled by some business propositions or like that. So the typical answer to the Kiranji's question, that what would be the timelines? Not coming up very upfront on this answer, it would be a sort of a diplomatic thing, what I'm going to say. It's a legislative process. The government would be coming up with a proposition, and then the inputs from all sectors would be taken up, and then the rules would get notified. So the same process is going to get replicated over here, and I hope that suffices the answer.
You're a lawyer. Definitely, that was a very, very skillfully deflected answer in terms of the exact timelines, but I think it is clear that it is coming, and I think it's time for all of us to prepare. I would like to go back to Anirudh. I think Anirudh, we had, if you look at DPDP, I think DPDP brings in a very strong consent-based approach to the use of health data. And I think many people in the health industry are already sitting on a lot of health data, right? So when it comes to, say, use cases like research, what does the law actually say? Can I use the data that I have now? Do I need to go back to the patient, seek additional consents before I can start using it for certain research? Help us a bit understand about what happens to existing data, and also, for if I wanted to say, if I'm starting a new research, do I have to explicitly ask for consent?
A fairly important question in the context of healthcare, I guess. I mean, obviously we all know that data can be, very, very useful for research purposes. Before I answer what's in the act in particular, just want to touch upon certain broad principles, right? Which is that if you were to technically anonymize the data, and anonymization here means that it is an irreversible process. There is really no way to now after the anonymization is done, there's no way to re-identify the individual, then technically that is not personal data, and this act will not apply to it. So if you were doing research after anonymizing data, you are free of the constraints of the act. But most of us, I guess, know that perfect anonymization does not quite exist in this world. There are several ways to, kind of re-identify persons, especially when you can, layer one data set over others that may be publicly available, etc. It is very, very difficult to kind of have perfect anonymization, and that is the problem, right? So if anonymization were possible, let's proceed with that assumption for a second. I think the other question to be asked is, if I am your data fiduciary, having data from, having collected your data, can I process the data? Or anonymization is also processing of data, right? So can I even run that process without your consent? I think that's a fairly technical point. I would like to believe that you can, but that's not. I just want to leave it as an open question for now. Now, the other thing that I want to touch upon is pseudonymization, right? Which is fairly in research circles a fairly standard way of approaching data, which is that you don't completely anonymize, but you say create a token right, and use that token, or you provide a certain team with data, but you remove name and other fairly obvious identifiers. Now, pseudonymization again does not equal anonymization, because the act is very clear. It has to be an irreversible process. So that again is not going to work. Now, there is an exemption under the law which is helpful, which says that there's a general exemption for research, provided the process is adhering to certain standards laid out, which will be laid out in due course. And the reason I went through this, kind of the larger principles of anonymization and pseudonymization is because I guess these principles are going to guide those standards, right? Those rules as they come true. So I'm assuming that there will be certain, the rules or the standards will refer to what level of pseudonymization or what level of anonymization, what will qualify as anonymization, etc. And we will have to adhere to those standards if we want to use that data for research. But as of now, there is an exemption. The specifics of it are not made available.
Hey, thanks, Anirudh. I think that was very helpful, and it's really interesting to see that an exemption has been carved out specifically for research. Rahul, I just want to come to you. I want to build on this idea of consent that's so important. I think one of the things that I really like about India's DPDP is the idea that it's actually a data empowerment kind of an architecture, where I am essentially the act allows me to use my data for my benefit with my consent in some ways. And I think we have examples like account aggregator, we have the health information exchange and consent manager as digital consent manager. So great to hear Deepak sir say that the rules are looking at consent managers as entities. And I think there have been technical architectures for consent managers that RBI has put up in terms of the account aggregator, NHA has done in terms of the HIECM. But one thing I always worry about with this is that when we're dealing with India is really a very, very large, diverse population, a very large percentage of the population also at the bottom of the pyramid, sometimes with just feature phones. So whenever we look at and deal with consents and consent managers, we are talking about our smartphone world where, we are seeing a consent, we talked about in the previous session about it being available in 22 languages, and then people having to consent. There is this, in my mind, there is an implicit view of a smartphone-like interface or device that kind of also is kind of put into place. So tell us a bit about, as you see this evolve, and I think you've been watching this closely, how do you see, what are the practical challenges you see of the implementation of the DPDP Act and then of consent managers, especially for the bottom of the pyramid?
Sure. Look, and I'm done with pessimism, so you're going to only hear optimism from me. One of the features of India's data protection framework in the here and now is that we are actually leveraging off this really powerful DPI story that over the last 9 months you've heard over the G20, etc. And over the course of that entire period, we're realizing how completely unique the framework and the infrastructure is that we've set up. So everything that you talk about, right, if you think about trying to get consent at the bottom of the pyramid, people sitting in this room with smartphones are thinking, when I signed up for that app, there was that page of terms of service, which I was supposed to read, but how many, hands up, how many people have read the terms of service of the apps? Anyone who's read the terms of service? There's one person, it's always one person in the room, but he must be working for the company that terms of service. We don't read it, right? And this is the reason why your question is so resonates so much with everyone, because the complexity of terms of service today makes it really difficult for us to then, understand, etc. But the power of data and the power of India's data empowerment and protection architecture, which is replicated in the account aggregator, in health and in various other sectors, is that it leverages what I call granular consent. Now, it's very hard to read through 20 pages of things that you have to agree to. But if you need to understand exactly why a lender wants what information, they will ask for 6 months bank statement in order to give you a loan for a motorcycle. Now, this is easy to comprehend. And they will take it only for that purpose, and they will give it up after that. Now, take the health use case. You want certain types of reports for the purposes of a second opinion. I'm making it up, but I'm saying we have a granular set of data that is required for a granular purpose that could potentially be time limited. This is not hard for people at the bottom of the pyramid also to understand. And it is not possible if you didn't have the type of digital system that we are building to enable this. So I would argue that without a digital consent manager framework, in the way that we have conceptualized it for the country, everything that you're saying is correct. The fact that we have a digital consent management system does not, off of itself, provide us with the comfort that we need that the people at the bottom of the pyramid will understand everything. And I don't want to be a techno-optimist and say technology solves everything. But it takes us a long way down that path. As you build these systems, all of you in this room have something to do with building the systems. Remember that consent under the DPDP Act, the obligation is informed consent. And I don't need to talk about the connotations of the word informed consent to a bunch of doctors or medical professionals. You know for many years what it means. You also know how it can be subverted. You know the complexities of trying to explain this to people. But with this granular consent, a digital framework, if you can think of ways in which you can make it understandable to the bottom of the pyramid, I think we have the best opportunity to be able to come up with a workable form of consent in this new framework.
Thank you. I just would like to continue to build on this consent a little more with, Dr. Ashok sir. The public health system is structured really as a whole bunch of vertical programs. There's a lot of software systems over the last decade that has been built. Each of these vertical programs are holding health data. And there's a lot of thought process of bringing all of the data across these programs in the context of a patient for better patient care. How do you view consent? Do we see each of these programs now as separate data fiduciaries, and to move data across these fiduciaries, do we now require additional consent? Are there other thought processes or otherwise that you're currently thinking about now with the DPDP app coming in?
Two, three terms I have heard quite often in speakers are informing you. One is government is sitting on a big data in a shells, fiduciary data shells. Let me tell you one thing. Government is sitting in that database, if you call it sitting, because government is the largest healthcare provider, at least in the primary health sector. Nobody is interested in it. That is the first part. And the second part is, the previous speaker was telling about informed consent. Government doesn't even work with informed consent.
it works with deemed consent. Say one mother comes with a baby as soon as she is born, give me polio vaccine. She comes to you. We don't want her to sign a big 20 pages document. It is deemed consent. This deemed consent is not just government is taking, but the person is giving because of trust. Because it believes whatever the data government is collecting, we don't have any pecuniary ideas to use it for some financial purpose, etc. At the maximum, we will link the data with one more shelf of data which you are talking, we gather data in silos. Say we run, we have huge database, there is no doubt MeitY must be having 24 lakh TB patients data, Goel must be having 220 crore data points, it runs like that. I just would like to give one example. One TB patient, unfortunately TB happens in the low socioeconomic profiles, one TB patient comes to you and after 2 or 3 months is not getting cured, okay? We have doubts whether it is a drug-resistant TB which he may have to take 2 years treatment. But it may not be the case. He may be having diabetes. That's why this TB is not getting cured. There is nothing wrong in taking the database from NCD portal because he is a TB patient and there is an ABA ID which uniquely identifies him and links up with the TB case. Oh, he is having diabetes. So we should be careful in first maintaining the blood sugar levels, then the TB treatment. This kind of decision, if it helps for a poor patient, I don't think we should think too much about, especially when person is trusting, too much about integrating data points, one cell to other things. And the second point, I don't know whether you go to a pharmacist and buy a medicine, after paying or before paying, you may check what is the expiry date, what kind of drug he is giving. Can anybody deem that a mother going there and checking and taking a polio vaccine when it is going to be expired, whether it is stored in particular temperature or not? This trust government has already established. That's why it is sitting on that kind of database. Government database, because at times it works in disease-based mode. MeitY is there, RCH portal is there, HMIS is there, that kind of thing. To help the really poor who blindly and for rightful reasons trust the government, we can have 2 or 3 things. One is summary consent, where we can automatically share within the data points, what we call the fiduciary shelf of things. Second thing is, we can create, these days we are thinking, we have started also in one particular portal, the access logs. Who has accessed, who has reached the other portal and log the data so that we get to know what purpose that person has reached. Of course, we are keeping one person who is superior to give the permission to access that log. Just, it is a need, that's all. It's a need, I mean to say, commonly one pregnant woman leaves the husband, goes to mother's place, delivers the baby there, gets the first vaccination of polio, BCG there, and comes back to the other district. If I say the other district A&M, you don't have rights to see the other district data. Unfortunately, it's not good. It's not good on our part. So I see 2 things. One is summary consent, where we can freely shuffle between the data points of different portals. And second thing is some access logs, who is accessing what with some superior's permission. Hope this should answer this question. Thank you.
Thank you, sir. Deepak, sir, just want to build on, Rahul spoke about, and I think, I am also a big proponent of digital consent managers. But I also worry about, account aggregators, financial sector, we have one consent manager, health, we have now a consent manager. And there are many sectors or domains in which my personal data is available. So what do we see as we kind of look at the future? A proliferation of consent managers now that the DPDP Act is in place. And also, where do you see the role of protocols and standards so that we are actually kind of building some kind of a more homogeneous architecture under the hood in this evolution?
Consent managers per se, they are something new and specific, very specific to the Indian context. Means we have never heard. Anirudh can verify whether they exist in any other geographies also. So between the 2019 construct and this 2023 construct of personal data protection, now the construct of the consent manager that he needs to have his face towards the data principles, means he needs to take care of the interests of the data principal, of course working as a data fiduciary. So specifically coming to the Kiranji's question, we have seen the success of consent manager in the RBI framework. We have seen quite a fillip in the innovation system that has occurred in the financial ecosystem. We have so many apps, so many fintech companies growing up through, shooting up through the roofs, and now the digital public infrastructure of financial ecosystem is just crossing the boundaries of the country also. One of those reasons is having the consent frameworks established with the help of consent managers. So now health is also having into, means getting shifted to this concept of consent managers. I think insurance we are already taking into, then health interface we are also working onto that. So right now this is the second sector where we are looking for the consent managers. So initially I think there would be some sectors who would be coming for the establishment of a consent managers, and as the technologies and as the usage of that particular this consent system, or say consent provisioning and consent withdrawing system grows, I think in the years to come we would be having some sort of a sector agnostic, or say sector neutral, or say domain neutral consent managers only, so that we have only a consent manager. It doesn't deal with the finance system, it doesn't deal with the health system, it's only dealing with the consent. So let's hope for that, and I hope another 4 or 5 years down the line we may have a thinking of a consent manager without having any, without linking it to a specific domain. Now the second question that you asked was related to the standards and protocols. I think for any system to grow in the sense, grow into the technology area, into the usage area, if we have some standards and some protocols established and understood by the industry, by the people, so that is going to flourish. So similarly, in this personal data protection ecosystem, DAPA framework has come up quite good as far as the standards and protocols have established. They have established to maintain a secure system. They are helping us in the auditability of the system. They are into the respecting and protecting the privacy of the individuals. They promote interoperability. So I think they are very critical. And if the ABDM is also just coming up with all those protocols and standards which can be applied to, say, our consent managers, I think that would help everybody quite a bit. Thank you.
Yeah, thank you. I think, sir, from an ABDM perspective, if we were already, I would call what ABDM consent manager is as DAPA maybe 1.5. So if there is a common DAPA framework that MeitY were to say all domains should adopt, I don't see any challenge for, say, the health sector and ABDM to actually adopt that as the underlying protocol. So that I think would be great. So Rahul, I have one last question before we close up on this. In the National Digital Health Blueprint, and I think Satya sir also talked about this, we visualized a privacy operations center. And I think just as a quick background, right? So in a world where consents are being exchanged, data is being exchanged with consents, one of the things that we were worrying about when the ABDM was being conceptualized was, could somebody use this digital public infrastructure to harvest data? Could I go around, gather data by collecting consent without letting people know, what the purpose is, or cheating people out and collecting data, and would that become an issue? And so that was one of the thought processes behind it. So what I just wanted to ask you, what's the current thinking on what does the law say right now about, is there any proactive detection for misuse and abuse of consent in the DPDP or anything that you think should be done?
So, look, I mean, I think, first of all, at this present point in time, we don't have a privacy law, right? So we're now starting from ground zero. So any of these things would have existed if there was an enforcement mechanism and all of those things. We're putting all of that into place right now. When it is put into place, I think around the world, this is one of the challenges with implementing privacy around the world. And you can see that it is a tension between the regulator and the regulated. So if you look at all the privacy cases around the world, it is how can I, who am collecting data, frame my consent in such a broad way that I can collect as much information as I can within what is permitted by the law. And around the world, data protection authorities are saying what you have done is framed your consent too broadly. If you look at the recent case of Google versus CNIL, the CNIL is the French Data Protection Authority. The French Data Protection Authority said, in order to understand the purpose for which I am using this information, I have to click through 4 separate pages. And that is not okay. So purpose must be easily prescribed. Now, no one knew this. Google is thinking, look, it's so much easier rather than putting it all on one page. I will give it easy, whatever you want to look here, you look here, then there's some other page you can look for something else. But the regulator is saying, no, that's too complicated. So to answer your question, I think what we're going to need to do is we're going to continuously need to innovate from the perspective of the data fiduciaries and the people who collect data and who use data to do all the things that we said, make it easy for people to understand, make it informed. But in doing that, we will push the boundary and someone will complain to say, look, no, I can't understand this anymore. It's too complicated or whatever. To which the regulator will come back and say, no, now I'm going to prescribe new ways in which you do it. This has been going around the world for 30 years. So India is slightly late to the game. But India has the advantage of having learnt from 30 years worth of global experience. We have the advantage of, in the meantime, having put in place a state-of-the-art digital infrastructure that the rest of the world is now sort of slightly jealous about, if we were to be completely honest. So we have a wonderful opportunity, really, to, one, learn from what all the other countries have gone through and apply it in our own unique digital way to achieve sort of modern outcomes. So, I mean, I am worried. I'm constantly worried as a lawyer that, that's what they pay me for, to worry about these sorts of things. But I am also very hopeful that if we continue with the approach that we have taken up until this time, we are going to deliver solutions that are going to be net positive. We're going to make mistakes, but what we need, and that's what he's for, is to quickly iterate, come up with new regulations, provide the guidance, and go forward.
Thank you. Satya sir, can I open it up for a few queries before I ask you to come back into summarization, please? Yes. Thank you so much, sir. So we can take maybe 2 or 3 queries from the audience. Can we get a mic to go around? Can I start with the lady at the end, please?
Hello, my name is Arjita Gupta, and as I'm a public health professional, and there has been still challenges on the collection of data. Okay, for example, NTEP for NICSHAY or to complete our TB elimination TB identity card, there's still 20 to 30 entries which needs to be filled. And the healthcare providers and for the frontline workers, that is not a primary purpose. Their primary purpose is to deliver the services. We are still somewhere lacking to complete the data set which we have, although I truly agree we have a lot of data set. Coming up with DPDP, can there be an innovative way where we can, address these challenges also, because coming with a consent, deemed consent and informed consent, this might be widen the gap where we have still some underreported data.
Who wants to take it? Basically, I think to rephrase the question, there is already a lot of form filling going on for every application, and now DPDP will say fill more consent forms. So what do we do?
Yeah, Kiran, if I can say, I think pretty soon, like in the West, we reach a stage of consent fatigue, number one, where you have to press more buttons for consent than the service itself. So we should definitely, being early in the game and early on the curve, I think we should be guarding against the design in such a innovative way, as Guptaji has mentioned. One could be, in Indian landscape, I would suggest is use in addition to things like deemed consent and summary consent, which are in fact provided for in some of the. I've been working in some of the Southeast Asian countries, and some of these countries do have a provision for deemed consent and the summary consent, like Ashok has mentioned. In addition, probably audio-visual aids can also be used to explain the essence of the 10 to 12 pages that Rahul was repeatedly mentioning, the essence of that, and then take the consent. So it becomes an informed consent. It is already being tried in some of the pilots, so I'm suggesting it's one of the way, but innovation can be, widely practiced, and, the country should think of, the startups could think of how to take this as, if you take this as a challenge or a consent fatigue as the problem statement, how do you overcome in a way that is simple to the user, user-friendly, and at the same time complies with the four corners of the law. So that's my response.
Yeah. Thank you, sir. Could we have somebody from, please.
Yeah. Hi, Kiran. I have two questions. One is regarding the terms and conditions of the privacy concern. We have more than 100 integrators integrated with the ABDM sandbox, but mostly we'll compare the consent manager and all with the UPI stack. Like in most of the cases, we give the example of UPI stack when we compare the workflow and all of the ABDM stack. So when it comes to the terms and conditions, like are we that strong, like when we compare with any payment aggregator integration and all, like, because like I see like most of the integrators that are live are having empty terms and conditions page and all. So are we that strong when, because like we are very strong in the digital payments because we have very strong payment page, like terms and conditions when it comes to the payment integration and all. When you want to onboard any e-commerce site, like at least the integrator will check, like the PG provider will check our terms and conditions and the written policy and all. Are we that strong in the ABDM? And the other thing is, like when it comes to the PHR app, like most of the PHR apps are free as of now. And the only value proposition that any PHR guy can see is a cross-selling. So will it be any challenge in future, like influencing any products, cross-selling and all? Will that be a challenge?
So I can answer the first question, the second question first. It's going to be a huge challenge, right? Because consent is in relation to a purpose. And if the purpose for the PHR is, I don't know, to maintain your health record, cross-selling certainly is not the purpose. And so if you misuse it, if you collect it for maintaining a PHR, and then you cross-sell it for insurance or whatever else you would do, it violates PDP from the start. So you could, as a PHR app, say that, look, I'm providing you this facility of maintaining your health record. If you like, I would also give you information about an insurance that would be useful to you. And if you say yes, then you can do it, because you've got consent for it. And on the first question, as a lawyer, I would like you to conflate long, detailed privacy policies with good privacy policies, but very often that is not the case. Very often the long privacy policies perhaps are just templates that people have put together without really thinking about it. I think that for this sector, certainly an empty privacy policy is a no-go. But if you can just deal with these two simple things, because that's how simple the new PDP law is. What is the personal data you're collecting? What is the purpose for which you are collecting it? Just these two things. There's lots of detail, but ultimately it boils down to these two things. And you can only do it for those two things. The rest of that is retention restrictions. How long can you keep it? You can only keep it for as long as it serves the purpose. After that, you have to delete it. There are many other provisions, but basically there is just these two. And so I would say that the entire UPI stack, which all the terms and conditions were built before PDP, before the DPDP, I think it can be radically simplified. And so we have the opportunity, particularly if you've got a blank set of terms and conditions, to use this simple process. That was the intention behind simplifying the law from even the 2018 version. So we should lean into that and come up with a set. And, I don't know, Kiran, we should try and come up with templates that people should use. I'm giving you a very simple, free of cost piece of advice. These are the two things you have to do. Build from that. And then, of course, you can come to me for all the other more complicated things.
Sir, can you have your query?
And we are basically trying to address an issue that people go to take health help only when they're sick or there are symptoms of being sick. We also want to be proactive to say that we can help you check your health early enough. With AI, unfortunately, as I feel after the discussions today, so that we are reducing the need for rushing to the OPD or to the emergency thing. And we are developing some apps. We are integrating innovations of a lot of other innovators into a platform. Now that becomes a challenge because I need to make sure that those platforms are also having the consent which is necessary, which is necessary. So I'm also, at the end of the day, the whole world is moving towards AI-based advice, generative AI, and which we are also exploring, because that is dependent on a lot of data which I collect. Suppose tomorrow if I'm evaluating 1 lakh people, whether they are fit or not, so that I can suggest to them early enough. Now, that data I definitely want to use to be able to generate my results better. So that is a challenge which I hope I can get some help, as you rightly said, that we look at the basic template and solve that. My suggestion otherwise was also that your ABDM is actually providing us an interface through your sandbox to certify the applications that are conforming to that. So you could probably perform that role more effectively over us for providing the APIs, or checking the data privacy part, or for checking the template part, so that it helps a bit. Thank you so much.
Yeah, I think just a viewpoint, sir, the whole idea of the ABDM compliance is to make sure that every party who agrees to participate in this digital health ecosystem essentially conforms to certain standards, and clearly, privacy, security, how they handle consent are all part of that. Yeah, please.
Right, thank you, sir. So my name is Saurav Raj. I'm a technology guy, and I've been intently listening to all the conversations. One of the things which we are doing is building a standard consent layer across health, finance, even as basic as simply sharing your Aadhaar card or driver license when you check into a hotel, right? Because you are giving some amount of personal data. My question to the esteemed panel is, do you see, or when do you see we could be at a point, India as a country, where we could give the data ownership to the user, to the actual end user? Because till today, all of the data is still residing with the fiduciary or with the organizations or entities which are generating those data points. So do you think we will reach a point where the data is with the user and owned by the user completely? Thank you, sir.
I'm just going to come in and add. it was a very, very similar question that I had. I'm Dr. Sohaila Kapoor from Health Save today. How are we going to encourage private hospitals to part with healthcare, patient healthcare data, which has always been a challenge? In the public setup, of course, there are like larger like goods, and there is a social cost to that. But for a lot of private hospitals, holding on to patient data has been one of the mainstays of kind of keeping a patient with them. How is ABDM, NHA, and the Ministry of Health looking at doing this? And that is one of the main questions which we get asked as a healthcare software solution company, that why would I share my like patient data with you? So just bring back control into the patient's hand is what I meant.
In fact, actually, we were discussing earlier that the DPDP Act is actually going to be an interesting thing because it does apply to all healthcare providers, including private healthcare providers. At this point, the rules or the Act says that a summary data of what you have can be shared. So it doesn't really still put the pressure to share all the health data, and it is something that we have to see how I think it's going to evolve in some sense. I think going back, I think if anybody wants to take the query of the gentleman about whether people will own their own data.
I think one of the longest debates we had before this PHR concept was introduced in ABDM, I think Kiran may be remembering, was what kind of a basis we should have. See, well-established, electronic health systems in countries like US and several other countries went the EMR EHR way as a priority, as the, that is the way things have evolved over 3 decades. Now, when this question came before ABDM, we debated intensively, conducted a lot of study of what happens in different countries. Then finally, as you see, ours is a PHR-centric, person-controlled health records, and coupled with federated health records. So we are certainly in the right direction in this way as step 1 towards empowering the people, I would say. Step 2, will it convert to a benefit to me? Can I benefit or monetize as a citizen of my personal health data? Is the next step. We have to cross, one at a time. But my feeling is we are certainly in the right direction with this combination of person-controlled PHR, where you can create your own, optionally your own ABA, and also go on adding your records, which has taken 30 to 40 years in some countries. We are going to leapfrog in that direction because of this. And at the same time, empower the citizens through this PHR approach.
Rahul?
Yeah, I just want to make a slight distinction because you're a tech guy. We shouldn't conflate possession with control. So I think what Mr. Satyanarayana said was that we are contemplating a federated system. So the health could reside in all the hospitals as long as I, as the person whose health it is, can easily access it at any time. Because we don't want to create a separate monster. If I hold all my data, I am not a hospital with the resources to be able to secure it, to be able to make sure that nothing happens to it, for it not to deteriorate. We need to create systems where I can access what I want, when I want. At the same time, I can rely on the power of large organizations and institutions to store the data, keep it always accessible. We have to think in those lines. And I think because we all want to, right now we're frustrated that I can't get the data out of the hospital. And so we think the alternative is to bring the data and keep it here. It's not. We don't have the systems to upgrade our whatever wallet we have to the next version of DICOM, because then all the various x-rays that I have or scans I have are no longer readable. Whereas the systems could. And we have to start thinking in this manner where we don't conflate possession with control and access. And as long as we can retain federated but still have easy access to it, I think we will solve this problem.
Thanks, Rahul. I think that's been so I'm really sorry, folks. We are going to be out of time. I'm going to request, I think this has been a wonderful and exciting discussion, at least in terms of learnings. Can I request our chair, Satya sir, to give his closing remarks?
Thank you, Kiran, for moderating this session excellently, and also for the very enthusiastic participation of all the invitees. I think it's very difficult to summarize such a complex subject and such a rich discussion in a minute or so. But let me just throw in a few key words that I picked up today. Not necessarily any order of importance, but first one is about purpose limitation, how elegantly, nicely and user-friendly manner you can get the consent in place in the Indian environment is one of the areas for innovation going forward when we are operationalizing the DPDP Act. If it is something extremely complex and it will be a non-starter and it will be only on paper. Really, we want people to really understand in a simple way. Then it's more democratic way of functioning. Democratizing health data. Second, on the provider side and the data fiduciary side, what is especially significant data fiduciaries perspective, what is required is more effective, more efficient systems of data governance. Because tomorrow for any act of omission or commission, the corporate entity or the entity behind the data fiduciary will be called in person and so on. So we have to, we meaning the data fiduciaries, whether public or private, need to tighten our belt and establish the standards, systems of data governance. That is, there is no kind of negotiation or shortcut for that. It has to be gone through. And the very important point that comes across is the distinction between ownership, possession, and control. So nicely brought out by Rahul. While the data principle, which is the citizen or a patient, now and forever will be the owner of the data, the possession may be, for obvious reasons, can be with the service provider. And certain obligations are cast as a data fiduciary. But again, the first and the last, ownership and control, both are in the hands of the citizen. So a PHR-centric, a person-centric approach to dealing with this is the right way. And that is the way we are going. And certainly things will evolve in that direction in the months and years to come. So with that optimistic and positive thinking, I thank all the panelists and also all the members in the audience for this very important and timely kind of discussion here. Thank you.
This has been a truly enlightening and equally intriguing session. We extend our gratitude to our chairperson, panelist, and moderator for their insightful contributions. To conclude, we'll be presenting mementos to our esteemed panelists. May I kindly request our additional CEO, Dr. Basant Garg, to hand out the memento to our chairperson, J. Satyanarayana. To Dr. P. Ashok Babu. And now to our moderator, Mr. Kiran Anandampillai. I would request Mr. Kiran Anandampillai to present these mementos to Mr. Deepak Goel, to Mr. Rahul Matthan, and to Mr. Anirudh Rastogi. Thank you everyone for attending this session. We have our next session on recognition and felicitation in hall number 6. It request you all to please attend the session.